Erie R. COV. Tompkins. Important case you should know about, Erie R. COV. Tompkins. A lot of people don't know this information, so I am simply giving you all what I have read on my journey. So you all can catch up. I'm not no guru, I just read, apply, execute. I retain a lot of information in a short period of time. Just showing real history of how we operate. Supreme Court. Lee greater than U.S. Supreme Court. 304 U.S. 6458 S. Court 817-82 L at 1188 Erie R. COV. Tompkins. Number 367. Argued Jan. 31, 1938. Decided April 25, 1938. Messrs. Theodore Kendall, Harold W. Bissell, and William C. Cannon, all of New York City, for petitioner. Argument of counsel from pages 65 to 67 intentionally omitted. Messrs. Fred H. Reese, Alexander L. Strauss, and Bernard G. Nemiroff, all of New York City, Bernard Kaufman and William Walsh, both of New York City, and Aaron L. Danzig, of Jamaica, L.I., on the brief for respondent. Argument of counsel from page 68 intentionally omitted. Mr. Justice Brandeis delivered the opinion of the court. 1. The question for decision is whether the oft-challenged doctrine of Swift v. Tyson 1 shall now be disapproved. Greater than ERIER. COV. Tompkins. Erie R. COV. Tompkins. 2. Tompkins, a citizen of Pennsylvania, was injured on a dark night by a passing freight train of the Erie Railroad Company while walking along its right-of-way at Huffastown in that state. He claimed that the accident occurred through negligence in the operation, or maintenance, of the train, that he was rightfully on the premises as licensee because on a commonly used beaten footpath which ran for a short distance alongside the tracks, and that he was struck by something which looked like a door projecting from one of the moving cars. To enforce that claim he brought an action in the federal court for Southern New York, which had jurisdiction because the company is a corporation of that state. It denied liability, and the case was tried by a jury. 3. The Erie insisted that its duty to Tompkins was no greater than that owed to a trespasser. It contended, among other things, that its duty to Tompkins, and hence its liability, should be determined in accordance with the Pennsylvania law. That under the law of Pennsylvania, as declared by its highest court, persons who use pathways along the railroad right-of-way, that is, a longitudinal pathway as distinguished from a crossing, are to be deemed trespassers, and that the railroad is not liable for injuries to undiscovered trespassers resulting from its negligence, unless it be wanton or willful. Tompkins denied that any such rule had been established by the decisions of the Pennsylvania courts, and contended that, since there was no statute of the state on the subject, the railroad's duty and liability is to be determined in federal courts as a matter of general law. 4. The trial judge refused to rule that the applicable law precluded recovery. The jury brought in a verdict of $30,000, and the judgment entered thereon was affirmed by the Circuit Court of Appeals, which held 2 CIR 90 F2D 603. 604, that it was unnecessary to consider whether the law of Pennsylvania was as contended, because the question was one not of local, but of general, law, and that, upon questions of general law the federal courts are free, in absence of a local statute, to exercise their independent judgment as to what the law is, and it is well settled that the question of the responsibility of a railroad for injuries caused by its servants is one of general law. Where the public has made open and notorious use of a railroad right-of-way for a long period of time and without objection, the company owes to persons on such permissive pathway a duty of care in the operation of its trains. It is likewise generally recognized law that a jury may find that negligence exists toward a pedestrian using a permissive path on the railroad right-of-way if he is hit by some object projecting from the side of the train. The Erie had contended that application of the Pennsylvania rule was required, among other things, by Section 34 of the Federal Judiciary Act of September 24, 1789, circa 28 U.S.C. Section 725, 28 U.S.C.A. Section 725, which provides, "The laws of the several states, except where the Constitution, treaties, or statutes of the United States otherwise require or provide, shall be regarded as rules of decision in trials at common law, in the courts of the United States, in cases where they apply." 5. Because of the importance of the question whether the federal court was free to disregard the alleged rule of the Pennsylvania common law, we granted certiorari. 302 U.S. 671, 58 S. Court 50, 82 L. ed. 6 First, Swift v. Tyson, 16 Pet. 1, 18, 10 L. ed. 865, held that federal courts exercising jurisdiction on the ground of diversity of citizenship need not, in matters of general jurisprudence, apply the unwritten law of the state as declared by its highest court, that they are free to exercise an independent judgment as to what the common law of the state is, or should be, and that, as there stated by Mr. Justice Story, the true interpretation of the 34th section limited its application to state laws, strictly local, that is to say, to the positive statutes of the state, and the construction thereof adopted by the local tribunals, and to rights and titles to things having a permanent locality, such as the rights and titles to real estate, and other matters immovable and intraterritorial in their nature and character. It never has been supposed by us, that the section did apply, or was designed to apply, to questions of a more general nature, not at all dependent upon local statutes or local usages of a fixed and permanent operation, as, for example, to the construction of ordinary contracts or other written instruments, and especially to questions of general commercial law, where the state tribunals are called upon to perform the like functions as ourselves, that is, to ascertain, upon general reasoning and legal analogies, what is the true exposition of the contract or instrument, or what is the just rule furnished by the principles of commercial law to govern the case. 7. The court in applying the rule of Section 34 to equity cases, in Mason v. United States, 260 U.S. 545, 559, 43 S. Court. 200, 204, 67 L. ed. 396, said, "The statute, however, is merely declarative of the rule which would exist in the absence of the statute." 2. The federal courts assumed, in the broad field of general law, the power to declare rules of decision which Congress was confessedly without power to enact as statutes. Doubt was repeatedly expressed as to the correctness of the construction given Section 34(3) and as to the soundness of the rule which it introduced. 4. But it was the more recent research of a competent scholar, who examined the original document, which established that the construction given to it by the court was erroneous, and that the purpose of the section was merely to make certain that, in all matters except those in which some federal law is controlling, the federal courts exercising jurisdiction in diversity of citizenship cases would apply as their rules of decision the law of the state, unwritten as well as written. 5. 8. Criticism of the doctrine became widespread after the decision of Black and White Taxicab and Transfer Company v. Brown and Yellow Taxicab and Transfer Co., 276 U.S. 518, 48 S. Court. 404, 72 L. ed. 681, 57 ALR. 426.6 There, Brown and Yellow, a Kentucky corporation owned by Kentuckians, and the Louisville and Nashville Railroad, also a Kentucky corporation, wished that the former should have the exclusive privilege of soliciting passenger and baggage transportation at the Bowling Green, KY, railroad station, and that the Black and White, a competing Kentucky corporation, should be prevented from interfering with that privilege. Knowing that such a contract would be void under the common law of Kentucky, it was arranged that the Brown and Yellow reincorporate under the law of Tennessee, and that the contract with the railroad should be executed there. The suit was then brought by the Tennessee Corporation in the federal court for Western Kentucky to enjoin competition by the Black and White. An injunction issued by the district court was sustained by the Court of Appeals, and this court, citing many decisions in which the doctrine of Swift and Tyson had been applied, affirmed the decree. 9. Second, experience in applying the doctrine of Swift v. Tyson had revealed its defects, political and social, and the benefits expected to flow from the rule did not accrue. Persistence of state courts in their own opinions on questions of common law prevented uniformity. 7. In the impossibility of discovering a satisfactory line of demarcation between the province of general law and that of local law developed a new well of uncertainties. 8. 10. On the other hand, the mischievous results of the doctrine had become apparent. Diversity of citizenship jurisdiction was conferred in order to prevent apprehended discrimination in state courts against those not citizens of the state. Swift v. Tyson introduced grave discrimination by non-citizens against citizens. It made rights enjoyed under the unwritten general law vary according to whether enforcement was sought in the state or in the federal court, and the privilege of selecting the court in which the right should be determined was conferred upon the non-citizen. 9. Thus, the doctrine rendered impossible equal protection of the law. In attempting to promote uniformity of law throughout the United States, the doctrine had prevented uniformity in the administration of the law of the state. 11. The discrimination resulting became in practice far-reaching. This resulted in part from the broad province accorded to the so-called general law, as to which federal courts exercised an independent judgment. 10. In addition to questions of purely commercial law, general law was held to include the obligations under contracts entered into and to be performed within the state. 11. The extent to which a carrier operating within a state may stipulate for exemption from liability for his own negligence or that of his employee. 12. The liability for torts committed within the state upon persons resident or property located there, even where the question of liability depended upon the scope of a property right conferred by the state. 13. And the right to exemplary or punitive damages. 14. Furthermore, state decisions construing local deeds. 15. Mineral conveyances. 16. And even devises of real estate. 17. Were disregarded. 18. 12. In part the discrimination resulted from the wide range of persons held entitled to avail themselves of the federal rule by resort to the diversity of citizenship jurisdiction. Through this jurisdiction individual citizens willing to remove from their own state and become citizens of another might avail themselves of the federal rule. 19. And, without even change of residence, a corporate citizen of the state could avail itself of the federal rule by reincorporating under the laws of another state, as was done in the taxicab case. 13. The injustice and confusion incident to the doctrine of Swift v. Tyson have been repeatedly urged as reasons for abolishing or limiting diversity of citizenship jurisdiction. 20. Other legislative relief has been proposed. 21. If only a question of statutory construction were involved, we should not be prepared to abandon a doctrine so widely applied throughout nearly a century. 22. But the unconstitutionality of the course pursued has now been made clear, and compels us to do so. 14. Third, except in matters governed by the federal Constitution or by acts of Congress, the law to be applied in any case is the law of the state. And whether the law of the state shall be declared by its legislature in a statute or by its highest court in a decision is not a matter of federal concern. There is no federal general common law. Congress has no power to declare substantive rules of common law applicable in a state whether they be local in their nature or general, be they commercial law or a part of the law of torts. And no clause in the Constitution purports to confer such a power upon the federal courts. As stated by Mr. Justice Field when protesting in Baltimore in Ohio, R.R. Co. v. Ba. 149 U.S. 368, 401, 13 S. Court 914, 927, 37 L. ed. 772, against ignoring the Ohio common law of fellow servant liability. I am aware that what has been termed the general law of the country, which is often little less than what the judge advancing the doctrine thinks at the time should be the general law on a particular subject, has been often advanced in judicial opinions of this court to control a conflicting law of a state. I admit that learned judges have fallen into the habit of repeating this doctrine as a convenient mode of brushing aside the law of a state in conflict with their views. And I confess that, moved and governed by the authority of the great names of those judges, I have, myself, in many instances, unhesitatingly and confidently, but I think now erroneously, repeated the same doctrine. But, notwithstanding the great names which may be cited in favor of the doctrine, and notwithstanding the frequency with which the doctrine has been reiterated, there stands, as a perpetual protest against its repetition, the Constitution of the United States, which recognizes and preserves the autonomy and independence of the states, independence in their legislative and independence in their judicial departments. Supervision over either the legislative or the judicial action of the states is in no case permissible except as to matters by the Constitution specifically authorized or delegated to the United States. Any interference with either, except as thus permitted, is an invasion of the authority of the state, and, to that extent, a denial of its independence. Hope you enjoyed the information. I'm only a guidepost. That means guide y'all behinds in these books and read. People don't like to read, and the people who created and run this system, are banking on keeping us ignorant from a lack of knowledge. Only being taught what they want us to know through the educational system.